There's a legal letter that costs $1 to send and forces any debt collector to either prove you owe the money or delete the debt entirely. Not reduce it, not negotiate it, delete it. Federal law gives them 30 days to respond with documented proof. If they cannot produce the original signed contract with your name on it, the debt disappears from your credit report, and they are legally prohibited from ever contacting you about it again. This is not a loophole some internet guru discovered last week. It is Section 809 of the Fair Debt Collection Practices Act, a federal law signed by the United States Congress in 1977. The Federal Trade Commission enforces it. The Consumer Financial Protection Bureau oversees it. Courts in all 50 states have upheld it for nearly half a century. One stamp, one certified letter, one legal demand that triggers a countdown no collection agency can stop. Then someone at one of the largest debt collection firms in America ran the numbers. The industry buys old debts for 4 cents on the dollar and collects the full amount from people who never question the bill. At $10, zero medical debt gets purchased for $400 and collected in full from the patient. That is a 500% profit margin built entirely on your ignorance of a law Congress wrote specifically to protect you. They did not hide this because it is complicated. They buried it because it is devastatingly simple. This is the story of the $1 letter the $20 billion debt collection industry prays you never send. Welcome to the channel. If these stories matter to you, hit subscribe and the bell. This is where we open the files the fine print was designed to bury. Now let me take you back to where this principle was born. The idea that an unprovable debt must be forgiven is not modern law. It is one of the oldest legal concepts in recorded civilization. In ancient Babylon, around 1750 BC, King Hammurabi's code, inscribed on a 7-foot stone pillar, required creditors to produce the original clay tablet, documenting a loan before any collection could proceed. If the tablet was lost or damaged, the debt was void. No proof, no payment, no appeal. In 326 BC, Rome passed the Lex Poetelia, abolishing debt imprisonment and establishing that creditors must present legitimate written documentation before claiming a debtor's property. Roman magistrates demanded the original agreement. No document, no case. In medieval England, the Limitation Act of 1623 imposed formal deadlines on creditors to produce evidence. Missed the window and the right to collect vanished permanently. Islamic law codified the same principle centuries earlier. The Quran explicitly states that debts must be documented in writing with witnesses present. Undocumented claims carry no legal weight. Every major legal tradition across 4 continents and 37 centuries arrived at the same conclusion independently. The person claiming money is owed must prove it. The burden has never once belonged to the debtor, until a $20 billion industry convinced you otherwise. Before I go further, everything I have revealed barely scratches the surface of what has been hidden from you. I spent months gathering the financial defense strategies, the legal techniques, and the consumer rights that corporations have buried for decades. All of it inside the complete vault. The debt validation letter template ready to print and send today. The credit dispute system that removes errors in 30 days. The statute of limitations guide showing which debts are already unenforceable in your state. The cease and desist letter that stops collection calls permanently. Over 10 guides in one place, no filler, straight to the point. The link is in the description. But stay right here because the federal data behind this law is about to make the collection industry very uncomfortable. In 1977, Congress passed the FDCPA after a decade of documented abuse. Collection agencies were threatening debtors with fake lawsuits, calling their employers, harassing family members, and demanding payment on debts consumers had already paid or never owed in the first place. The law gave every consumer a single devastating weapon. Section 809, the right to demand debt validation. Validation does not mean the collector sends you a letter restating that you owe $4, $0. That is a claim, not proof. Validation under federal law means producing the original signed credit agreement, a complete and itemized payment history from the original creditor, documented proof that the collection agency is legally licensed to collect in your state, and verification that the statute of limitations has not expired. Here is the detail the entire industry is built on hiding. The vast majority of consumer debts in collection have been sold and resold in bulk portfolios. A bank writes off $50 million in delinquent accounts and sells the entire package to a debt buyer for $2 million, 4 cents on the dollar. The buyer receives a spreadsheet, names, addresses, social security numbers, and balances. In most cases, they do not receive original signed contracts. They do not receive payment histories. They receive a list and a phone number, and they start calling. A 2013 study by the Federal Trade Commission found that more than 50% of debts sold to collection agencies contained errors in the balance owed. A 2015 report by the Consumer Financial Protection Bureau revealed that debt buyers possessed the original signed credit agreement in fewer than 35% of accounts purchased. 35%. That means nearly 2 out of every 3 debts being actively collected across America right now may lack the documentation required to prove you owe a single cent. The entire industry operates on one bet, that you will pay when a stranger calls with a number and a threatening tone without ever asking the only question that matters. Can you prove it? If you have made it this far, you already know more about your legal rights than 99% of Americans receiving collection calls today. Subscribe and share this with someone drowning in calls they may not legally owe. Everything the industry buried is inside the vault. Link in the description. Now stay with me because this is exactly how you do it. Step 1. Within 30 days of the collector's first written contact, write a debt validation letter. State that you're exercising your rights under Section 809 of the Fair Debt Collection Practices Act. Dispute the alleged debt in its entirety. Request the original signed agreement bearing your signature, a verified payment history, proof of licensing in your state, and confirmation that the statute of limitations has not expired. Step 2. Take the letter to any post office and send it via certified mail with return receipt requested. The certified receipt creates a legal paper trail proving the collector received your demand. Total cost, approximately $5 for the stamp and certification fee. Step 3. Wait. From the moment the letter is delivered, the collector is legally required to cease all activity. No phone calls, no letters, no credit report updates. The law is clear. Step 4. They have 30 days to respond with complete documentation. If they produce the originals, the debt stands, and you negotiate from an informed position. If they cannot, and government data shows that in the majority of purchased debt cases they cannot, they must remove the account from your credit report and stop all contact permanently. If they violate any of these requirements, you can sue for up to $1,000 in statutory damages per violation, plus your attorney fees under the FDCPA. Now, I need to be completely honest with you about the limitations because this process is powerful, but the internet has exaggerated parts of it. The 30-day window to send your validation request starts from the collector's first written notice. If you wait beyond that window, you can still dispute, but the legal protections are strongest within it. This method works best on older debts that have been sold multiple times, where original documentation is most likely lost in the chain. For recent debts with the original creditor, they can usually produce full paperwork. This does not erase debts you legitimately owe and that are fully provable. It exposes debts that cannot be substantiated, which the government's own data shows is a staggering number, and the resolution takes up to 30 days, not 72 hours. The letter takes 15 minutes to write, but the legal clock runs for a month. The debt collection industry generates $20, $7 billion per year in the United States. Profit margins on purchased debt routinely exceed 300%. They buy your forgotten hospital bill for pennies and demand thousands. The entire model depends on one assumption, that you do not know what Congress handed you in 1977. One certified letter dissolves that assumption. For 700 years, every civilization has demanded proof before collection. Hammurabi carved it into a stone pillar. Roman senators voted it into law. The English Parliament codified it in 1623. The United States Congress reinforced it in 1977. The burden of proof was never yours. The collection industry spent 47 years making sure you believed it was. Your great-grandparents settled debts with a handshake and a paper receipt. They never received a threatening call from a company that bought their obligation from another company, that bought it from another company, that bought it from a bank, that already wrote it off as a loss. The entire architecture of modern debt collection depends on layers of complexity designed to discourage you from asking one devastating question. Prove it. $20 billion in annual revenue depends on your silence. One letter ends it. If this vault changed how you see that collection notice on your kitchen counter, subscribe and share this video now. Every share arms someone with legal knowledge. A $20 billion industry spent decades making sure they would never find. The next vault opens soon, and what is inside could save you more than any letter ever will.